Then the next important aspect here is relating to minor admitted to partnership. So minor admitted to partnership, section 30. So here, a person who is a minor according to the law to which he is subject may not be a partner in the firm, but with the consent of all the partners for the time being, he may be admitted to the benefits of the partnership. So here, capacity to contract is very important for parties to for a partnership agreement also. So in that sense, minor does not have the capacity to contract. So, however, he can be admitted for the benefits of the partnership by in what manner? By with the consent of all the partners who are there for the time being. And what is the age of till which he will be considered to be a minor? The law to which he is subject will be the applicable law. In our country, Majority Act 1875, Section 3 says the age of majority of persons domiciled in India. Every person shall attain majority on his completing the age of 18 years and not before. So anyone who has not completed 18 years, if he wants to be admitted as a partner, he cannot be. If he can be admitted only for the purpose of getting the benefits of partnership, then that too he can be admitted only based with the consent of all the partners who are there at that point of time in the partnership firm. So then what is the right and liability? So such minor has a right to such share of property and of the profits of the firm as may be agreed upon, and he may have access to and inspect and copy any of the accounts of the firm. So here he is admitted to the benefits, and benefit is in the case of partnership firm is a share in the profits. So that share in the profits will also be agreed upon at the time of admitting the minor. So during the course, he is entitled for that share. Then he has access to, he may have access to and inspect the accounts and also take a copy of the accounts of the firm. So such minor's share is liable for the acts of the firm, but the minor is personally not liable for any such act. So there is a share which is given to the minor and a share of profits and benefits that are going to be given. So that share of the property and share of the minor will be financially liable, but there will not be any personal liability for any act in case of a minor. So it's only its share and financial liability that will be there, but no personal liability. So here, what are the minor's rights? He has right to share in the property as per the agreement, and he has right to profits as per the agreement. Then he has right to have access to the accounts and inspect and copy any of the accounts. But this right has to be provided by the, it is there, but it has to be provided by the existing partners. But if they are not providing, what is the instance? We will have to see section, the subsequent subsections. The minor liability is only for the acts of the firms, and there is only financial liability to the extent of his share, but there is no personal liability. Then what happens if actually they agree to give him a share in the profit, they agree to provide him a copy of accounts, etc. But if they don't do that, can an action be brought about? That is what is discussed in subsection 4, which says, such a minor may not sue the partners for an account or payment of his share of the profits or profits of the firm. Share of the property or profits of the firm. When can he do that? So, as a principle, while he is continuing in the partnership as a person who is entitled to benefits, if the share of property is not given, if the share of profits is not given, or if the accounts are not produced to him, so then he cannot sue the partners, but he can sue only when severing his connection with the firm, and in such case, the amount of his share shall be determined by valuation made as far as possible in accordance with the rules contained in section 48. So here, as long as he is continuing or he has an intention to continue, he cannot sue, either if the profits share is not given or if the share of property is not given or accounts are not shown or a copy of accounts are not shown to him. But if he wants to file a case for getting these, then he will have to sever his connection with the firm. And once he severs his connection and files a case, his share of property will be determined in accordance with section 48. So 48 is a provision which deals with the mode of distribution of assets and allocation of profit, etc., which is in the provisions relating to dissolution. The chapter dealing with dissolution, we will have section 48. So here, now the suit is provided. So the provisos provide an opportunity for a partner to use this suit for dissolution of the firm itself, or all the partners to agree to get the court to take up the matter as if it's a suit for dissolution of the firm. So it says, provided that all partners acting together or any partner entitled to dissolve the firm, upon notice to other partners, may elect in such a suit to dissolve the firm, and thereupon the court shall proceed with the suit as one for dissolution and for settling accounts between the partners, and the amount of the share of the minor shall be determined along with the shares of the partners. So if the suit by the minor is filed, the only thing that will happen is the court will examine that and indicate that you distribute whatever share is there in accordance with section 48, and his portion will be taken and the firm will continue. But in this particular suit, if all the partners acting together or any partner who is entitled to dissolve the firm according to the terms of the partnership agreement, then he will give a notice to all the partners and elect in this particular suit filed by the minor that he will ask the court that you dissolve the firm, and in which case the suit by the minor will be treated as a suit for dissolution and settling of accounts between all the partners. And just like in this resolution where the minor's share is determined, all the shares of the partners are also determined and distributed. So the provision says that minor cannot ask for accounts or share of property or profits while continuing in the firm. He can ask for them and sue partners only when he wants to sever connection with the firm. In such a case, his share is determined by valuation norms as per rules in section 48. In this suit, a partner authorized or all partners, after notice to all partners, may opt for dissolving the firm. The court will proceed as if it's a dissolution and for settling accounts between the partners, and the share of minor and the partners will accordingly be determined and distributed. So now what happens if the minor attains majority? So at any time within 6 months of the minor attaining majority or of his obtaining knowledge that he has been admitted to the benefits of the partnership, whichever date is later, such person may give public notice that he has elected to become or he has elected not to become a partner of the firm, and such notice shall determine his position as regards the firm. So here, it may so happen that someone may be admitted into the benefits of a partnership, but he may not be aware of it. He may probably get awareness of this at some later point of time. So, which could be even after he has attained his majority. So, the section talks about the choice that is given to the minor. So, if the minor, after he attains majority, within 6 months of his attaining majority, he has to give it by public notice, indicate whether he wants to continue and become a partner or whether he wants to not continue and opt out of the partnership firm. And that notice will determine his position. Suppose he gets to know about this later, after he has attained 18 years also, and at that point of time, from there 6 months after of his getting the notice, whichever point is later, he should give a public notice to indicate that whether he wants to continue in the firm or he wants to go. Provided, what will happen if he fails to give the notice? Then there is a default option that is there, that is, he shall become a partner in the firm on the expiry of the said 6 months. So, if he does not exercise his choice of either to become a partner or not to become a partner, either after attaining majority or within 6 months, of attaining majority or 6 months of getting to know that he is admitted into the benefits of the partnership, whichever is later, then after the 6 month period is over, he will automatically become the partner. of the firm. Then where a minor has been admitted as a minor, where any person has been admitted as a minor to the benefits of the partnership in a firm, the burden of proving the fact that such person had no knowledge of such admission until a particular date after the expiry of 6 months of his attaining majority shall lie on the person ascertaining the fact. So what is the burden of, who has the burden to prove that he got knowledge about it only now? So it will be on the person who is asserting the fact. So here, power of the minor to elect becoming or not becoming a partner has to be exercised within a period of 6 months of majority of attaining majority, or 6 months of knowledge of admission to benefits, whichever is later. And he has to elect by public notice. Again, section 72, you will have to see. What is the default option if he does not give his notice? He becomes a partner automatically after the expiry of 6 months. So the benefit of time beyond 6 months after attaining majority for exercising choice to not become a partner only if he proves that he has a knowledge of being admitted as a partner for benefits and he got to know about it recently. Only then he will be in a position to get the benefit of 6 months period after his majority also. Then so the burden of proof is on the minor if he does not want to become a partner, and on the partners if they want the minor to share the liability. So I'm a partner. When will I indicate that I got to know what is it only now? Because the default option, I don't want to become a partner, then I will say that I got to know about it just now. So the minor will have to prove in case he does not want to become a partner. So the other consequence of this fellow becoming a partner is the liability will be distributed amongst the minor also. So the personal liability also will start if he becomes a minor. So to spread the liability, the partners in the existing firm or third parties would want him to be also brought into the partnership firm, in which case they will have to prove that he already knew about it, but he is not exercised his choice. So the default option of him becoming a partner has to operate. Then where such a person becomes a partner, his rights and liabilities as a minor continue up to the date on which he becomes a partner, but he also becomes personally liable to third parties for all the acts of the firm done since he was admitted to the benefits of the partnership, and his share in the property and profits in the firm shall be the share to which he was entitled as a minor. So if the minor becomes a partner, so the minor's rights and liabilities will continue till the date he becomes a partner. Then on becoming a partner, his rights, as far as the share of property will remain the same, share of profits will be remaining the same as it was when he was a minor. As far as the liability is concerned, he was already having the financial liability up to his share, which will continue to operate. But personal liability to third parties for acts done by the partnership will continue, will date back to the date from which he has been personally admitted into the benefits of the partnership. So the personal liability also will kick in from a back date, the date on which he has been admitted into a partnership. Now, in case he does not choose to become a partner, what will be the impact will be subsection 8. So where such person elects not to become a partner, his rights and liabilities shall continue to be those of a minor under this section up to the date on which he gives public notice. And his share shall not be liable for any acts of the firm done after the date of the notice, and he shall be entitled to sue the partners for his share of the property and profits in accordance with section 4, subsection 4. Then nothing in subsection 7 and 8 shall affect the provisions of section 28 of the Act, which deals with holding out. So the rights and liabilities, the minor chooses not to become a partner, then the rights and liabilities continues to be those of the minor till he gives public notice. And after he gives public notice, his share is not liable for any acts of the firm after the date of the notice. Then second thing is he can sue the partners for his share of the firm property and profits according to subsection 4, where he will file a case and then he will ask for his share to be given, and in that same share the court will decide his share and make the payment to him, and he will be allowed to go. So If he does not give a public notice, then there are two consequences. One, he will be admitted into the partnership by default. The second thing is he will be held liable for holding out as far as the other parties are concerned. So in his interest and in the firm's interest, they have to, there has to be a notice about his choice. And that notice has to be published in accordance with section 72. So in this section 72, there are two types of public note. There are two variants for public notice. One, for registered firm, what is the procedure, and unregistered firm, what is the procedure. For a registered firm, the procedure is there has to be a notice given to the registrar. The second thing that has to be done is a notice has to be put in the official gazette. It has to be notified in the official gazette. Then the third thing is an advertisement has to be given in a notice has to be given in a vernacular newspaper operating in the district where the place of the business of the firm is located. So a registered firm, all the three modes have to be used. In case of an unregistered firm, anyhow, they are not registered, so you don't have to intimate the registrar. However, you have to give a notice in the official gazette. Then you have to give a notice in a vernacular newspaper operating in the district where it is, where the place of business is of the firm is located. So only when this kind of a notice is given will the requirements of public notice be fulfilled. So